Hello again, PS 110 students. In this video I'm going to go over some of the content, the first part of Chapter 4, Civil Liberties, which are your protections against national government actions. And at the beginning, this was applied only at the federal level. It didn't apply to things that the state government was doing because Fifth Amendment guarantees of due process were applied to national, not the state of Maryland government actions, and that goes back to McCullough that we talked about in a previous video. What are these Bill of Rights in precision? You have the right of raps, which are religion, assembly, press, petition. All of these rap are symbolic speech measures that have been interpreted differently according to the spirit of the times by the court. Number 2, you have the right to raise a militia, which interpreted in the 20th century came to mean that you had the right to bear arms. Number 3, there's not supposed to be any sort of militarization of the home. There will be no quartering of troops in private homes or domiciles. That came out of the American Revolution when the British seized private homes and quartered their soldiers in them. Amendment 4 deals with search and seizure limitations. There are processes or rules that police must follow when they are arresting people. Number 5 is a very, very important amendment. It guarantees due process of law, and this is one of the foundations of American jurisprudence. Without this, nothing else can go forward. You are not to be denied this guarantee of the Fifth Amendment. It also talks about no double jeopardy and no self-incrimination. You can't be tried for the same crime twice. If new evidence comes up which points towards guilt of a defendant, a new case is going to have to be formed. They can't go back and recharge somebody for the same process. And you cannot force somebody to incriminate themselves. 6, you have the right to a jury trial in civil suits over a certain amount of dollars. That has changed over the years. Originally, it was only $25. It's much more than that now. 7th Amendment is trial by jury. 8, there are no cruel or unusual punishments constitutionally. This has also changed radically over time, depending upon the spirit of the times. At one time, in the early 1970s, the death penalty was illegal everywhere in the United States. This is no longer the case today. This has been decided now because of federalism at the state level. Some states have the death penalty, some don't. 9 are rights retained by the people, and 10 are rights retained by the states. In other words, if it doesn't exist, this is how the original Bill of Rights viewed those future possibilities. And 10 has been used to justify the new federalism by many conservatives. Once again, rights are obligations. Liberties are protections against. And in the next video that I will do, I will expand on these 7 different areas where rights have been expanded. And this has been done through the incorporation doctrine. Selective incorporation slowly applied the 14th Amendment. Without this Civil War amendment, ladies and gentlemen, there would have been no chance to nationalize the Bill of Rights, legally speaking. Eventually, because of incorporation, it is extended everywhere, not just against national government actions. Why? Because of the Equal Protection Clause, which said that there is going to be no discrimination on how law is applied because of race, creed, or color. Everybody has equal civil rights according to that important Civil War era, the immediate aftermath of the Civil War Amendment. And then it will lay dormant until Brown. Barron, I just mentioned. Brown and Gideon will also be very, very important cases, and I'll get back to these in a moment. This particular document goes into more detail on explaining them. in Brown, which ended discrimination in education. It ended the separate but equal concept, which came out of Plessy v. Ferguson in Louisiana in 1896, which said that separate but equal was constitutional. In railroad card facilities, there is a car for colored people, there is a car for white people. Homer Plessy sued and he lost because the court at that time, because of the spirit of the times, which is about white supremacy, they viewed that particular dichotomy as being constitutional. Under strict scrutiny, this is unconstitutional because the facilities, obviously in the 1950s, are different depending upon your race. And because of that fact, they struck down this idea of separate but equal because the facilities were inherently unequal. Schools were using hand-me-downs and second-rate materials, old musical instruments that the other schools were no longer using. And they wanted to apply a single national 14th Amendment standard to the rights and liberties of all citizens. And these cases go a long way towards nationalizing the Bill of Rights. MAP is the exclusionary rule, which clarified search and seizure procedures under the Fourth Amendment. You can't go into somebody's home looking for one thing, find something else, and then charge them with another crime. You're going to have to come up with another writ and reason for obtaining that evidence. If it's illegally obtained, it is inadmissible in a court. Gideon, famous case where Clarence Gideon was incarcerated. He kept petitioning the Supreme Court to hear his case because he didn't have a lawyer, he didn't have any representation in court, and eventually the court combined his case with many other Deep South cases and agreed that in felony cases, criminal offenses, an attorney should be provided. And then by the early 1970s, the court takes this even further in Argusberger and applies it everywhere. That's where the private public defender lawyer comes in. You now have a right to a lawyer in any sort of criminal proceeding. Miranda clarified the rights of the accused under the Fifth Amendment. You have the right to remain silent. Anybody who's ever watched any police shows has seen the police use those measures. And Benton was another case that ruled against double jeopardy. You can't be accused or tried for the same crime twice. Griswold is another important case. Roe deals with abortion. McDonald, the right to carry handguns. This is a recent case from Chicago. According to this, yes, and this again will be applied at the state level. Some states are allowing people to carry firearms once again. Backey is reverse discrimination, and the Bollinger cases deal with affirmative action. You definitely need to be familiar with these cases. More detail. Freedom of religion. The wall of separation goes back to Mr. Jefferson. He is the one who really wrote most of the religion rules. They followed many of his writings from the state of Virginia, and they're still used somewhat today. The Establishment Clause. The Congress shall make no law respecting an establishment of religion, because you are free to practice whatever faith you wish, because it's something that goes on within yourself. And the state from without does not have the right to tell you what that should be. The Lemon test is still used somewhat. If an action has a secular purpose, you can have a Christmas play in a school because it's an educational tool. You're teaching kids how to act on stage, how to memorize lines. That is an educational thing. It's not just about Jesus. Does it lead to excessive entanglement? Then you can't do it. So if it doesn't promote or inhibit the practice of religion, then it tends to be allowed. You can't have excessive entanglement, and you can't promote or inhibit. And that is allowing for free exercise. Speech. Political speech, ladies and gentlemen, is pretty much guaranteed, even if it's insulting or outrageous. It's been consistently protected by the courts, except where it's inciting people to lawless action or violence. And in that particular case, that KKK leader was arrested for that. And later the Supreme Court said that, well, just because he talked, he didn't really incite people to violence, whether he did or not. Again, these are the politics of rights. Another interesting area is campaign finance laws. Those have changed all over the place in the last 25 years. Some people view this as their money and in violation of their freedom of speech or their symbolic speech in supporting a particular political candidate. And there's been various ways around federal laws, and this is an ongoing thing that it's very gray as to what it really means. Right to life. Speech Plus has been upheld many times. They were allowed to burn draft cards back in the 1960s. Because, again, it was viewed as political speech, and in the spirit of those times, it was allowed. The flag can be burned for that reason as well. I don't recommend doing that in the state of Texas. Prior restraint is forbidden, except under the most extraordinary circumstances. If you're going to do these activities, these petition or symbolic speech activities, get a permit. If you're doing them on private property, there's going to be problems. These types of speech are definitive. You have no right to slander or libel someone. Libel is written, slander is spoken, and that is a reckless disregard of the truth and is unconstitutional and is illegal in the United States. But it's going to have to be proven that there was some malicious or intent, scandalous intent. And without that proof, then you have no case. And these are some of the reasons why pornography is legal in the United States. Again, that's more of a state function. It depends on where you live. Fighting words and hate speech are difficult to interpret. If it promotes violence, it's not going to be allowed, but hate speech is protected. Commercial speech is heavily regulated. You're not allowed to use false or misleading advertisement. I can remember when cigarettes were advertised on TV. That has been banned because they believed that they had a compelling state interest to get rid of the promotion of tobacco. We talked about the McDonald case, which affirmed the right to bear arms under the Second Amendment. Due process is 5, and these other amendments are also involved in that part of American jurisprudence. Because of the war on drugs, the hard line stand established by MAP has been amended, and also by the events of 9/11. Now it's not so much probable cause, but reasonable is enough to get a warrant. The grand jury process is something that goes before the legal courts. In the grand jury, they are going to determine whether or not there is enough evidence, and that's where a lot of cases end. They're not ruling on guilt or innocent, but whether or not there's enough to keep going, and sometimes the district attorney's going to end it there because they don't think they have a good case. We've talked about eminent domain, and if your public land is being taken, you're probably going to be compensated for that. I mentioned Argersinger earlier. That extended the right of counsel to all cases. Esconbedo was also another case related to Miranda and the rights of the accused. Be familiar with Gideon and the right to counsel in criminal activities. The death penalty, as I mentioned, has changed many times. It overturned it in 1972 because it was viewed as being applied in not valid ways. It's being applied more to minorities than it was in other people. But then they changed this in Gregg versus Georgia in 1976. And that's where we basically are today, that it's a state level matter. The Griswold case, without this, the right to abortion would not be permitted. Griswold established the right to privacy, what William O. Douglas, one of the most fervent defenders of the Bill of Rights and absolute rights according to what the letter and what is written, he said the right of privacy fits into a zone of privacy that was created by a combination of the Third, Fourth, and Fifth Amendments. Because there is this idea of right of privacy, in 1973 in Roe, they established a woman's right to an abortion based on the 3-trimester idea. That has since been modified many times. There is still the right to an abortion, but depending upon what state you lived in and what trimester the pregnancy is in, many third trimester abortions in many states now are illegal again. And in terms of gender discrimination, one of the other areas of the expansion of civil rights in Lawrence, since 2003, state legislatures no longer have the right to make private sexual behavior a crime. And another interesting area of rights, in 2006, the court upheld an Oregon law allowing doctors to use drugs to facilitate the deaths of terminally ill patients. When Dr. Kevorkian was around, the court was looking at it much differently than that. In the early 1990s, at that time, they said that this was not a right that doctors had. And that ends this particular section of Chapter 4.